Hi, I'm Darcel Lobo. I own Dow Law Firm, and today we're going to answer the question of why someone would want a revocable living trust. What are the benefits of it? What's the difference between a revocable living trust and a will? So we're going to cover all that today. And a lot of my estate planning consultations that I have with clients when they come in, they're usually not sure which one they want, or they've heard certain things online or heard from a family member or friend, different things. So we're going to just kind of set everything straight and try to help you determine what's best for you. Now, I'm going to start this out by saying that whatever you want your distributions to be, if it's to children or other family or to friends or charities, whatever you want to have happen, we can do that in a trust or in a will. They both can do the same thing as far as what the end result is. The question is, how do you want to get there? How do you want your estate to proceed? How do you want it to be administered upon your passing? That's the difference. So whatever you want to do in one, you can do in the other. Excuse me. It's just a question of how are we going to get there. So let's kind of briefly define the two different options, a revocable living trust and a will. A will is a set of instructions of what you want to have happen to your estate upon your passing. Now, when I say estate, what does that mean? An estate really is all of your assets and all of your debts. That is your estate. It can be real estate, it can be financial accounts, it can be vehicles, it can be a boat, it's your personal property, all of your things that you own, and then also whatever debt you owe, that is your entire estate. So how do you want all that transferred? When your assets are liquidated, your debts are paid, whatever is left, how do you want that distributed? That's what we're talking about when it comes to your estate. Sometimes people can think an estate means someone who's really rich and has, millions or more of dollars. No, everyone has an estate when they pass. It can be very small, it can be very big, or somewhere in between. Okay, so that's what I'm referring to when I talk about your estate. Whatever your assets are, whatever your debts are, and whatever the net distribution will be to whoever you have named. So the will is a set of instructions of what do you want to have happen to your estate when you've passed. Who do you want it to go to? Who are your heirs? Who do you want to be in charge, commonly called the executor or the personal representative? That's their job in the will to make those things happen. However, your will is a set of instructions, but it doesn't actually empower anyone to make those distributions happen. Well, how do they get that power then? Once you pass, how can they do the things that they need to do? Through probate. Probate is a court process where the judge assigned to the case oversees the administration of your estate, so of your assets and your debts and distributions to your heirs, pursuant to the terms of your will. So your will says, I want my estate to go to A, B, and C. The probate court, the judge assigned to the case, is going to oversee the liquidation of assets, payment of debts, and making sure the net proceeds goes to person A, B, and C, whoever you have outlined in your will. So upon your passing, let's go over what happens. You've passed, a death certificate is issued upon your passing, then the will and the death certificate and some other documents are filed with the probate court to officially open probate for your estate, and that's when letters testamentary are issued. A lot of times clients will come to me when someone's passed and say, the bank said I need letters testamentary. That's what that is. That is an order from the probate court saying that the executor is the person who's been appointed by the court to act on behalf of your estate. Now let's compare that to a revocable living trust. With a revocable living trust, you put your assets into it during your lifetime. We assist you with that if we're preparing your trust for you. You are your own trustee during your lifetime. You manage all of your assets, pay your debts, just as you have been. But upon your passing, in your trust, you have named someone as your successor trustee. Your successor trustee is then the person who is in charge of the trust, and it's their job to follow the distributions as you have outlined in your trust. So they liquidate assets, they pay debts, and they make distributions to whoever you have named in your trust. So person A, B, and C, whoever that might be, they do that. The biggest difference, they don't have to go through probate. That is the difference between a will and a revocable living trust. Is your estate going to go through probate? So what are the pros and cons? Why would someone want their estate plan to be in a will versus in a revocable living trust? I usually see 3 big reasons why someone would want a trust instead of a will. Number 1 is that they don't want their estate, their family, or whoever they have named to be in charge and their heirs to have to go through probate, to have to go through a court process, to have those hoops to jump through to administer their estate. So they don't want their estate to go through probate. They want whoever's in charge to be able to take over and take care of everything without having to go to court. That's reason 1. Reason 2, my clients want more privacy. With a will, when it gets filed with the probate court, the will becomes public record. Anyone can look up the court docket to see what your estate comprised of, what your assets were, what your debts were, what the value of everything was, and how much all your heirs received. That is all public record. When probate is open, that's all filed into probate and anyone can see that. Whereas with the revocable living trust, there is no probate, there is no public record of the trust, what the assets were, what the debts were, and what everyone inherits. So it's not public record, so the privacy that the trust provides is a big reason why some clients would want a trust over a will. And third reason is that if I have a client who either currently owns real estate outside of Washington state, or if they plan to in their near future. Like some clients, they'll have their home here in Washington, but they may have a second home in Arizona, California, Hawaii are kind of common places where my clients may have other property. Or maybe they've inherited other property outside of Washington state. If you go with the will option, there's going to be a probate for your estate in every state where you owned real estate. So if you have a home here in Washington and you have a second home in Arizona, there's going to be a probate in Washington and in Arizona. So if you have real estate outside of Washington state, or if you plan to do so in your future, then sometimes in that situation, the revocable living trust can be a better option for you. So those are kind of the 3 big reasons why a client would want a trust over a will. But again, whatever you want your distributions to be, we can do the same thing if it's a will or it's a trust. Just how do you want to get there? What vehicle are we going to use to get your estate distributed? Because I will tell you, the will is less expensive to set up. The trust is more expensive. However, with the will, there's going to be probate costs on the back end. When you combine the will and probate costs, that's going to exceed the cost of the trust. But for some clients, I understand that finances are a factor, and so they want to do a will because at this point in time, that's what works for them financially. And I want you to have an estate plan. So I prefer that you have a will estate plan rather than having no estate plan. Because if you don't have an estate plan in place, you don't have a will, you don't have a trust, you don't have beneficiaries, you don't have all the different options for estate planning. If you don't have an estate plan in place, the state of Washington has an estate plan for you. We have one by law for people who do not have wills or trusts or have otherwise provided for the distribution of their estate. And the estate plan that the state has for you may not be what you want it to be. The person that a judge picks to be in charge of your estate may not be the person that you want to be in charge of your estate. So if you have been putting off getting your estate plan done, I understand that's pretty common among my clients, and that's okay, right? At least we're here now getting this done for you. So if you've been putting it off and haven't gotten it done, but it's one of those things that you know you need to do, give our office a call. Our number is 206-408-8158. You can visit us online at dowlawfirm.com. I will have all that listed below for you. I am only licensed in Washington State. If you are outside of Washington State, I'd have to refer you to your state bar association to get a referral to an attorney licensed in your state. But if you're in Washington, you need to get your estate plan done, or maybe you have an old will or an old trust from 10, 20 plus years ago, and you know it's time to kind of dust that off, review it, update it, make some changes. We can help you with that as well. So again, contact info is below. I'm Darcel Lobo, the owner of Dow Law Firm, and I'd be happy to help you. All right, I'll see you in the next video.